Grab your coffee and let's get into court.
Good morning. Okay, sorry I was running a bit late. I had to make my coffee, but it literally looks divine for this Monday morning. I hope everybody's having a great Monday so far. Court just got live, so I'm going to bring it up and we will get into court. Okay, so happy Monday. We'll chat more as soon as we get a chance, but I don't want us to get too far behind.
Oh, okay. Counsel for the state are present. Counsel for the defendant are present, along with Ms. Richins. We're set this morning for a closing argument. Mr. Bloodworth, is the state ready to proceed?
Yes, Your Honor.
Ms. Lewis?
We are.
Okay. Anything before we invite the jury in? Mr. Bloodworth?
No, sir.
Ms. Lewis?
No, Your Honor.
All right. Okay. Cody, we're ready for the jury.
We are getting right to it today.
Oh, all right. Very good. Well, so it goes.
Or did I speak too soon? Okay, so unlike Karen Reed, it'll go state, defense, state rebuttal, and then I'm not sure if this legislating takes before or after. I'm assuming after. So we might have a verdict today, although I don't know.
While I have this moment, if one member from each of your respective teams would plan to meet with Brittany after closings are complete, just confirm that we have consensus regarding the exhibits that we're sending back into the jury room.
Yes, Your Honor. Can we address physical evidence as well? I don't think we're requesting to send any physical evidence back, but I'm not sure.
For example, the glassine bags of the gummies, et cetera.
Correct.
Okay. I wasn't planning to send those back, Ms. Lewis.
That's fine.
Okay. Very good.
Your Honor, is the court sending a computer back for the kind of audio video files? Got it.
We have a air gap computer that will not attach to the internet or connect to the internet, that they'll be able to use to view files off a thumb drive.
Right, Your Honor.
Did everyone have a good weekend? Feels like we're waiting on the jury. Somebody may be running a little bit behind. Oh, I don't know, Sydney. We do have bad storms. It's like just now stopping, but it's still super windy. Is it laggy? Let me refresh. We don't need this. It doesn't look laggy on my end. Yeah, we had terrible thunderstorms and rain and high wind all weekend. Like, trees are all down everywhere. And it's still windy, but the sun just came out. Okay, maybe if you guys try going completely out of YouTube and coming back in, it doesn't look laggy for me. I'm gonna look on my phone.
All right, Jerry.
Have a seat as you come in, please. Have a seat, please. Ladies and gentlemen, welcome back. We will begin this.
Okay, just for extra measure, I'm going to refresh the live. So just a second.
You have two main duties as jurors. The first is to decide from the evidence what back with you into the jury room to review during your deliberations. And we can fast forward to instruction number 13. The preceding pages before instruction 13 are just a written copy of the jury instructions the court gave prior to opening statements. Closing roadmap. Members of the jury, you now have all the evidence. Three things remain to be done. First, I'll give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. Prosecutor will go first, then the defense. Because the prosecution has the burden of proof, the prosecutor may give a rebuttal. Finally, you will go to the jury room to discuss and decide the case. You have two main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. You are the exclusive judges of all questions of fact. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend upon what you decide are the true facts of the case. If an instruction applies only to facts or circumstances that you find do not exist, you may disregard that instruction. Please perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. You must also not let yourselves be influenced by public opinion. Regarding closing arguments, when the lawyers give their closing arguments, please keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. During the trial, I've made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Please do not interpret anything I've done as indicating that I have any particular view of the evidence or the decision you should reach. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witnesses said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments are not evidence. In reaching a verdict, consider all the evidence as I have defined it here and nothing else. You may also draw all reasonable inferences from that evidence. Regarding items not admitted into evidence, transcripts, police reports, or other written audio or visual materials may have been referenced during the trial but not admitted as exhibits. It's common during deliberations for these materials or to have transcripts of what witnesses said during trial. These materials, other than what may have been admitted as exhibits, may not be requested as part of your deliberations. Regarding witness credibility, in deciding this case, you'll need to decide how believable each witness was. Please use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you're convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one, or one witness against many. In deciding whether a witness testified truthfully, please remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Evidence has been presented that a witness was previously convicted of a crime. This evidence was brought to your attention only to help you evaluate the credibility of that witness. Do not use it for any other purpose. It is not evidence of anything else. An informant is someone who provides evidence against someone else for a personal reason or advantage. The testimony of an informant alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though not corroborated or supported by other evidence. You must examine and weigh an informant's testimony with greater care than the testimony of an ordinary witness. You must determine whether the informant's testimony has been affected by self-interest, by an agreement they have with the government, by their own interest in the outcome of the case, or by prejudice against the defendant. You should not convict a defendant based on the unsupported testimony of an informant unless you believe the unsupported testimony beyond a reasonable doubt. A person may testify under a grant of immunity, that is, an agreement with the government. Their testimony alone, if believed by the jury, may be of sufficient weight to sustain a verdict of guilt, even though it's not corroborated or supported by other evidence. You should consider testimony given under a grant of immunity with greater care and caution than the testimony of an ordinary witness. You should consider whether testimony under a grant of immunity has been affected by the witness's own interest, the government's agreement, the witness's interest in the outcome of the case, or by prejudice against the defendant. On the other hand, you should also consider that an immunized witness can be prosecuted for perjury for making a false statement. After considering these things, you may give testimony given under a grant of immunity such weight as you feel it deserves. You should not convict a defendant based on the unsupported testimony of an immunized witness unless you believe the unsupported testimony beyond a reasonable doubt. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crime charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, And in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. The defendant has entered a plea of not guilty and denies committing the alleged crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume the defendant is not guilty. The defendant does not have to prove anything. She does not have to testify, call witnesses, or present evidence. Regarding direct and circumstantial evidence, facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified that he looked outside, saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. You have heard evidence that before or after the alleged acts charged in this case, the defendant may have done the following: made false statements connected to the financial affairs of her business, engaged in an extramarital affair, or made false claims about whether she was the sole author of a book. This evidence was not admitted to prove a character trait of the defendant or to show that she acted in a manner consistent with that trait. You may consider this evidence, if at all, for the limited purposes of determining motive, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Keep in mind that the defendant is on trial for the crimes charged in this case, and for those crimes only. You may not convict the defendant simply because you believe she may have committed some other acts at another time. Regarding fact versus expert witnesses, there are two types of witnesses: fact witnesses and expert witnesses. Usually, a fact witness can testify only about facts that he or she can see, hear, touch, taste, or smell. An expert witness has scientific, technical, or other special knowledge that allows the witness to give an opinion. An expert's knowledge can come from training, education, experience, or skill. Experts can testify about facts, and they can give their opinions in their area of expertise. You may have to weigh one expert's opinion against another's. In weighing the opinions of experts, you may look at their qualifications, the reasoning process the experts used, and the overall credibility of their testimony. You may also look at things like bias, consistency, and reputation. Please use your common sense in evaluating all witnesses, including expert witnesses. You do not have to accept an expert's opinion. You may accept it all, reject it all, or accept part and reject part. Give it whatever weight you think it deserves. You have heard the testimony of law enforcement officers. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is up to you to give any witness's testimony whatever weight you think it deserves. Regarding the defendant not testifying, a person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Regarding conduct and mental state, a person cannot be found guilty of a criminal offense unless that person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted, she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it's enough that the defendant acted recklessly or with criminal negligence or with some other specified mental state. Later, I'll instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. Some definitions. On or about includes any day that is near the day alleged in the information. For pecuniary gain means for the acquisition of money or something of monetary value. Attempt means the actor engages in conduct that constitutes a substantial step toward the commission of the crime and intends to commit the crime, or when causing a particular result is an element of the crime, acts with an awareness that her conduct is reasonably certain to cause the result. Conduct constitutes a substantial step toward the commission of the crime when it strongly corroborates the actor's required mental state to commit the crime. Utter means any intentional act that puts a writing into circulation and implies, by word or action, that the writing is genuine. Unless these instructions give a definition, you should give all words their usual and ordinary meanings. Elements of count 1, criminal homicide, aggravated murder. Kouri Richins is charged in count 1 with committing aggravated murder between on or about March 3rd and March 4th, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find, beyond a reasonable doubt, each of the following elements. Kouri Richins intentionally or knowingly caused the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 3 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Elements of count 2, attempted criminal homicide, attempted aggravated murder. Kouri Richins is charged in count 2 with committing attempted aggravated murder on or about February 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins attempted to intentionally or knowingly cause the death of Eric Richins under one or more of the following circumstances: for pecuniary gain or by means of the administration of any substance administered in a lethal amount, dosage, or quantity. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you are not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. To find the defendant guilty of attempted aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt. You must also unanimously agree which circumstance or circumstances the prosecution has proven. You will mark your decisions on the verdict form. Definitions of mental state relate to counts 1 and 2. For the purposes of counts 1 and 2, a person acts intentionally or with intent when her conscious objective is to cause a certain result. A person acts knowingly or with knowledge when the person is aware that her conduct is reasonably certain to cause a particular result. Elements of count 3, insurance fraud. Kouri Richins is charged in count 3 with committing insurance fraud between on or about January 29 and August 31 of 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, intentionally, knowingly, or recklessly devised a scheme or artifice to obtain anything of value by means of false or fraudulent pretenses, representations, promises, or material omissions, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 4, insurance fraud. Kouri Richins is charged in count 4 with committing insurance fraud on or about June 14, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with intent to deceive or defraud, presented or caused to be presented any oral or written statement or representation as part of or in support of a claim for payment or other benefit pursuant to an insurance policy, certificate, or contract. Knowing that the statement or representation contained false, incomplete, or fraudulent information concerning any fact or thing material to the claim, and the value of the property, money, or things obtained or sought to be obtained is or exceeds $5,000. After you carefully consider all the evidence in this case, if you are convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Elements of count 5, forgery. Kouri Richins is charged in count 5 with committing forgery on or about January 29, 2022. You cannot convict her of this offense unless, based on the evidence, you unanimously find beyond a reasonable doubt each of the following elements. Kouri Richins, with purpose to defraud anyone without the authority to do so, did make, execute, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person. After you carefully consider all the evidence in this case, if you're convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you're not convinced that each and every element has been proven beyond a reasonable doubt, then you must find the defendant not guilty. Definitions of mental state for counts 3, 4, and 5. For purposes of counts 3, 4, and 5, a person acts intentionally or with intent when her conscious objective is to engage in certain conduct. A person acts knowingly or with knowledge when the person is aware of the nature of her conduct, or is aware of the particular circumstances surrounding her conduct, or is aware that her conduct is reasonably certain to cause a particular result. A person acts recklessly when she is aware of a substantial and unjustifiable risk that certain circumstances exist relating to her conduct, but she consciously disregards the risk and acts anyway, or her conduct will cause a particular result, but she consciously disregards the risk and acts anyway. The nature and extent of the risk must be of such a magnitude that disregarding it is a gross deviation from what an ordinary person would do in that situation. Conduct means either an act or an omission. Separate consideration of multiple crimes. The defendant has been charged with more than one crime. It is your duty to consider each charge separately. For each crime charged, consider all the evidence related to that charge. Decide whether the prosecution has presented proof beyond a reasonable doubt that the defendant is guilty of that particular crime. Your verdict on one charge does not determine your verdict on any other charge. Regarding jury unanimity, because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. That is, you must be unanimous in your verdict for each count charged. To help you in reaching unanimous agreement, I recommend that you not commit yourselves to a particular verdict before discussing all the evidence. In addition, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, in the jury room, please consider the evidence and speak your minds with each other. Listen carefully and respectfully to each other's views, and keep an open mind about what others have to say. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not guilty. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. Let's pause there for now. That went a little quicker than I anticipated. Mr. Bloodworth, would you like to proceed?
Yes, Your Honor, we may proceed and then maybe take
Let's
an intermission.
go.
We lost.
No problem. We sure did. Mr. Bloodworth, would you like me to publish the slide deck now?
Yes, Your Honor, please.
There you are. Please proceed.
Thank you. Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison, and her mother a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. She met Eric Richins. He was a successful business owner. He had money. They had a son, married, and had 2 more sons. Kouri Richins was on her way. But she was unhappy. She wanted to leave Eric Richins, but did not want to leave his money. Their prenuptial agreement meant that if she left him, she would also leave most of his money. So, Kouri Richins took $250,000 in equity out of Eric Richins' home without him knowing it, so that she could start her own business and earn enough money to leave Eric Richins. Kouri Richins is intensely ambitious. First with Eric's money and then other people's money, Kouri Richins carefully curated the facade of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks. She borrowed money by any means necessary at exorbitant rates. She gambled other people's money and lost. Her business was imploding. All the while, Kouri Richins was more interested in spending time with Josh Grossman than Eric. She dreamed of living in the Midway Mansion with Josh, running it as an event center, farming and raising kids, Eric's kids. But she did not have the money to leave Eric or the money to salvage her business. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die.
Wow, that quote is powerful.
As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. The state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count, and then within each count, element by element, to show to you how the state has met its burden of proving aggravated murder, attempted aggravated murder, 2 counts of fraud, and forgery. That, again, is the reasonable doubt instruction that Judge Mrazek just read, and you will have back with you in the jury room. Judge Mrazek also read this instruction on what evidence is, and it's usually testimony and exhibits. To reiterate, what the attorneys say is not evidence. And as I asked you in opening, please focus on the evidence. Throughout this presentation, I generally use this format for slides. And so everybody understands where we are, the count, and then the element within the count is at the top in the red banner. We then quote some witness testimony and we cite it. because it's the evidence that matters. So that you'll have the exhibits back with you when you deliberate, and you can reference them. Usually it's a transcript, page, line, number of the testimony. We also publish exhibits. And usually we'll have an exhibit number down here. If there's an exhibit, whatever, 2-5, so you can reference it. Let's begin with the aggravated murder count. The evidence will prove that Kouri Richins was the person who committed the aggravated murder. The evidence will prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Carmen Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. That's what matters. That's murder. These two elements are just murder, right? If we hide this, that's a murder charge. Here we have an aggravated murder charge, and the state will prove two separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? For money. The second aggravator is a how aggravator. How did she do it? Here, by the administration of any substance, here it happens to be fentanyl, but it could be any substance administered in a lethal amount. Either one of those aggravators are what transforms this case from a murder case to an aggravated murder case. So, first element, was it Kouri Richins? Yes. The state has proved that Kouri Richins had the means, here the fentanyl, the illicit street drugs, the motive, here money, and a fresh start at life, and the opportunity to kill Eric Richins. She was the only other adult in the home at the time. Nobody else killed Eric Richins. Now, intentionally or knowingly caused the death of Eric Richins by administering the illicit street drugs. The state will prove with all kinds of evidence, testimony, exhibits, patterns of her behavior, and what each of us know about humans, that she intended to cause Eric's death. She intended it probably as early as December the 7th, 2021, when she booked a trip for her and Josh Grossman to the Caribbean for April. People don't book that trip. Kouri Richins did not book that trip thinking Eric Richins would be alive in April. She booked it knowing he would not. In December, before Eric died, before Kouri Richins murdered Eric, she told her friend, Becky Lloyd, in many ways, it would be better if he were dead. That proves she intended to cause his death. This was the New York Life policy that covered the C&E buy-sell agreement. And on January the 1st, 2022, Kouri Richins changed the life insurance beneficiary on Cody's policy from Eric to her. The evidence proves that Kouri Richins didn't understand that was Cody's policy. And when she figured it out, she went ahead and changed it back because she planned to murder Eric. She did not plan to murder Cody, but she planned to murder. Kouri Richins asked two people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world, but she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because it is lethal, it is fatal, it kills. And she wanted lethal, fatal death. Kouri Richins is intensely ambitious. She wanted the perfect life, or at least the appearance of the perfect life. And for her, that meant Josh Grossman. But first, Eric had to go away.
So with these transactions, when Carmen hit you up, what did she tell you?
She just told me she had a friend that wanted,
Did she ask for blue specifically or fentanyl specifically, or did she ask for oxygen? What did she ask for?
I think she might have asked for blue. I can't remember.
But you sold her M30, right?
Yeah, I told her what she knew what she was buying.
Okay, so it wasn't like she's asking for oxys or something like that, and she got the M30.
Right, no.
Okay, so she knew that there was fentanyl in those pills.
At Kouri Richins' request, Carmen Lauber purchased illicit street drugs from Robert Crozier. It's those illicit street drugs that killed Eric Richins. It's those illicit street drugs that Kouri used to murder Eric Richins. And while there may be some question as to whether she specifically ordered fentanyl or she knew she was getting fentanyl, the evidence proves she at least knew it. She wanted fatal, lethal, illicit street drugs. And all the testimony from Carmen Lauber, Robert Crozier, digital forensics, we'll get into it, all confirm that Kouri Richins ordered and received illicit street drugs, and that those street drugs contained fentanyl. Illicit street drugs is all that matters. But you heard the testimony that despite confusion in what people were ordering, people were getting fentanyl. The fake M30s looked like the real, the fake M30s looked like the real M30s. Everything on the street in early 2022 had fentanyl. That's how we know that it was this purchase that ended up killing Eric. It's the fentanyl. We can trace the fentanyl. Next slide. The digital forensics corroborate Carmen Lauber's testimony that 5 days before Kouri Richins murdered Eric Richins, Carmen Lauber purchased for Kouri Richins fentanyl from Robert Crozier at the Maverick in Draper. The call detail records show an extraordinary amount of overlapping communication between Carmen Lauber, Kouri Richins, Carmen Lauber, Robert Crozier during that time. We, of course, don't have the communications. Carmen Lauber deleted them because they were evidence of a drug deal. Kouri Richins deleted them because they were evidence of a drug deal and a murder. Robert Crozier said he had lost his phone. But that's an extraordinary number of communications. We know that Kouri Richins, the evidence proves that Kouri Richins used a Moscow Mule and a shot to administer the fentanyl to Eric. She writes it in her orange notebook where she journals what happened the night she murdered Eric. It's a self-serving journal. We'll discuss that down the road. But she wrote Moscow Mule and a lemon drop shot. And that is consistent with all the toxicology. Again, in the notes that investigators recovered from the kitchen cabinet in Kouri Richins' home, she wrote Moscow Mule. Lemon water, vodka, and rum. Of course, is the ginger beer. But there was ginger beer. We know that from the cock and bull that OME investigator Cam Sessions found in the trash can in the kitchen. It's interesting that Kouri Richins wrote vodka in parentheses rum. The evidence may show that the Moscow Mule she made that night was ginger beer and fentanyl. The lemon drop shot may be lemon and fentanyl. Notice that here she writes drink in bed. We'll come back to that in a minute. The cock and bull, as I mentioned, corroborates at least the Moscow Mule. And that we know the cause of death from the death certificate was fentanyl. The fentanyl and the illicit street drugs that Kouri Richins got from Carmen Lauber, who got from Robert Crozier. We know that Eric ingested the fentanyl from the Moscow Mule, the lemon drop shop, or both. Medical examiner Dr. Pamela Ulmer, toxicologist Brianna Peterson, chief medical examiner Dr. Eric Christensen all testified that the 20,000 nanograms per milliliter of fentanyl, an extraordinary amount, in his stomach indicates oral ingestion. Indeed, Dr. Christensen not only testified to it, he told Kouri Richins that in their phone call that she recorded. Ms. Peterson's testimony, as well as Dr. Christensen, also proves that the fentanyl was illicit. Again, illicit coming from the street, illegal street drug, illicit fentanyl. And it was their testimony, right, was that there was not only fentanyl in the toxicology, but there was norfentanyl, which was a marker of an illicit fentanyl. There's also acetyl fentanyl as well. But it's the norfentanyl that is a marker of illicit fentanyl, which completely tracks with how Kouri Richins got the illicit street drugs. We also know that Kouri Richins intended to kill Eric Richins because the toxicology contained quetiapine.
Your Honor, we may have lost the audio.
Let's reset. My apologies.
Okay, is it better for everyone? Like, I don't see that once it said that. Whoa, he is doing so good.
Is an antipsychotic medication.
Last one. What is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay.
It's a prescription, mental health medication.
Mm-hmm.
It's prescribed for different things.
I gotcha.
The quetiapine in the toxicology for Eric Richins shows that Kouri Richins was involved because she was prescribed quetiapine. Now, this conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her prescription. Of course she knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She feigns the ignorance.
Gosh, I love this so much.
She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter. In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911. The evidence proves that is not true. The evidence proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
She then unlocked her phone again at 3:08, 3:10, 3:15, 3:19, and then 15 minutes later, she called 911. That is not immediately called 911. Perhaps she was staging the scene during these 15 minutes. We're going to discuss the 911 call in a minute. This is a receiver activation. At 3:22:12, when we're in the 911 call, she's on receiver on her phone. The 911 call operator asks her, "Are you on speakerphone?" She says yes. No. She's on receiver. Before we play this, sorry. We're going to listen to the first part, actually most of the 911 call again. I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow. To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a black widow. Listen to how Kouri Richins on the 911 call immediately presents, or very soon after the call begins, presents her alibi narrative. Listen to how she tells the 911 dispatcher where she was when Eric died. She is distancing herself. Rather than, he's not breathing, he has no pulse, I have to figure out what to do, I need help. She's saying, hey, look, I was not there, I was in my son's room. That's her alibi. She's distancing herself from the time and the place that she murdered Eric. The 911 call operator asks her to perform CPR. Notice how she distances herself from that. No, I don't know how. No, he's too heavy. No, I can't move him. She is not immediately trying to revive him. We're going to run a clock from the time that the dispatcher asks her if she can start CPR to the time she purportedly starts it. It's 6 minutes. Listen, please, to the portion of the 911 call where the operator instructs Kouri Richins how to remove Eric from the bed. Listen how the dispatcher says, move to the side of the bed. Kouri Richins says she does. Remove the pillows, pull the arm, pull the leg, lift up the sheath, pull him off. If Kouri Richins is following the instructions of the 911 dispatcher, Eric Richins' body is on the floor on the side of the bed, not the foot of the bed where it was found. Listen also to her choice of language. She has dehumanized Eric Richins. When she is talking about removing Eric from the bed and she is protesting and she is saying she cannot, she is not saying, I can't move him. She is saying, I can't move it. Eric is no longer a him to him. She murdered Eric. Eric is an it. Finally, listen to when she says she is performing CPR and the phone is on speaker. The phone's not on speaker. Determine whether she's performing CPR. Okay, Scott.
My husband's not breathing. He's cold. Okay, what's the address? 282 Willow Court. 282 Willow Court. Okay, what's a good phone number in case we get disconnected? 435 971 4987. Okay, it's going to be in Francis. Okay, tell me exactly what happened. I don't know. I was sleeping with my kids. Okay, I can't understand you. I need you to take a deep breath. What's going on? I don't know. I was sleeping in with my kids. I just came in our bed, and I turned over, and he's just cold. He's just cold. Who's cold? My husband. I turned the light off. And he's not breathing? He's not breathing? No. I need you to confirm it for me. Is he not breathing? No. Okay, can you do CPR? No, I don't know how. You don't know? I'm going to tell you how to. Are you willing to do CPR? Yeah. Okay. If there's a defibrillator available, send someone to get it now and tell me when you have it. No, thank God. Available? Okay. I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next, okay? Okay, are you right by your husband right now? Yeah, he's so pale. His mouth is open. Okay, listen carefully. Are you able to lay him on the floor or the ground? On the ground? I'm just thinking. I can't touch him. I can't. You can do it. You need to calm down, okay? We need to help him. I can guide you through CPR. Take a deep breath from me. I'm here with you. He doesn't have a pulse. He doesn't have a pulse? No. There's no pulse. Okay. I'm here with you. I'm here with you. We need to get him help. If you need to put me on speaker, put me on speaker. I'm gonna guide you through CPR, okay? Okay.
Where's that face now?
You've done that. Okay, I'm ready. You're ready? Okay, he's on the floor? He's on the bed. Okay, are you able by any chance to move him on the floor? Let me check. Thoughts on it. I don't know what's happening. I'm here with you. Are you not able to move him to the floor? Go out. Don't come in here. Oh my God, my sister. You're not able to move him to the floor? Just listen carefully. We just need to get him on the floor. Don't worry about hurting them. Don't need to be heavy. Is he still on the bed? Yes. Okay, if there's a sheet or a blanket under them, can you loosen it from the mattress? Yes. Okay, stand at the side of the bed closest to them and remove anything under the head. Okay. Okay. I need you to pull the sheets towards you and slide them off the bed. Don't worry about him falling. We just need to help him now. Okay. Tell me when he's on the floor. I can't move it. It's a dead weight. Like it. You're not. If he has sheets under, pull them to the floor. Don't worry about hurting him. Can you please send somebody? Okay, I have the ambulance that's on the way. Okay, There's another way to do this, okay? Grab their feet. Grab his feet. Okay. Slide them towards you until they're just off the bed. How old is your husband?
39.
39?
Yeah.
Okay. Okay, were you able to put his feet off the bed?
Absolutely.
Okay, now grab the arm closest to you and pull the rest of the way off the bed. Again, don't worry about the fall. We just need to help them now. I have the ambulance on the way. I just need you to do this, okay, so we can get the help for him.
Okay.
When they arrive, they'll take over. We just need to start CPR now. You are doing great, okay? I just need you to get him on the floor.
Okay, broken floor.
You got him on the floor?
Yeah.
Okay, listen carefully, okay? Make sure that there's nothing under his head. Is he laying flat on his back?
Yeah.
Okay. Okay, just listen carefully and I'll tell you how to do chest compressions, okay? Place the heel of your hand on the breastbone. This is in the center of the chest, right between the nipples.
Okay.
Put your other hand on top of that hand.
Okay.
Okay? Start pumping the chest hard and fast, at least twice per second, and 2 inches deep.
Okay.
Okay, start counting out loud so I can count with you, okay? We're gonna count 1, 2, 3, 4, okay? Let me know when you're ready.
1,
1, 2, 3, 4. One, 2, 3, 4. Count out loud so I can hear you. I'm counting with you. 1, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. 1. If it's easier for you, am I on speaker?
yes.
Okay. 1, 2, 3, 4. Do you know if the front door is open?
No, it's locked.
I need you to go. Is there anybody else within the home or is it just you?
It's all my kids.
Okay. Are one of them old enough to go unlock the door?
Yeah, it's unlocked.
It's unlocked now?
Yeah, he's here. He's here.
Okay.
The protesting that was part of the 6-minute delay in Kouri Richins performing CPR. I can't move it. It is just dead weight. Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him. None of that happened. She's covering up her involvement in murdering Eric Richins. Recall the alibi narrative at the beginning of the 911 call. Her letting the 911 operator and everyone know that she was not with Eric when he died. I was somewhere else. I was distant in place and time. When she calls her father-in-law, Eric's dad, Gene Richins, What does she say right at the outset? I was sleeping with Ashton and I came into the room. Gene, I wasn't there. Wasn't me. When Eric's sister Katie arrives, he wasn't breathing. I went to bed. I was in Ashton's room. He was having nightmares. I wasn't there. It was not me. Her alibi. Her cover-up. This is the written form that sheriff's deputies gave Kouri Richins early morning of March 4th to write out what happened. It says, describe in detail what you saw, know, or heard of the incident. Where does she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink. She didn't start with, I walked into the bedroom at 3 a.m. My husband was not breathing and cold. Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began. And then more of her self-serving alibi narrative. It wasn't me, I wasn't there. Before she gets into really what matters. Intentionally or knowingly caused the death of Eric Richins. We know it was intentional because she planned the immediate reaction. When she spoke with Eric's sister, Katie, very shortly after medical examiners rolled Eric Richins' body out of his home for the last time, she told Katie that she was going to plan the she was going to follow through with the purchase of the Midway mansion. She was going to sell the home that she was living in. And she had a plan for running Eric's business, C&E. The morning of Eric's death. She had those plans in place because she knew she was going to murder Eric. She had already thought about not only murdering him, but what I'm doing immediately after murdering him. Her plan with the Midway mansion is consistent with her dream of living there with Josh Grossman, running it as an event center, farming and raising Eric's kids. Her plan to sell the home she lived in proves that she had no idea that home was in a trust. And she couldn't sell it. Her plan on running Eric Richins' half of C&E shows that she did not understand the buy-sell agreement, the life insurance coverage on the buy-sell agreement, or that life insurance coverage went to the trust, not her. The morning Eric died, she had a plan on how she was spending Eric's money and didn't realize it was trust money. We know that Kouri Richins intended to kill Eric. The evidence proves that she intended to kill Eric, in part based on her conversation with Josh Grossman shortly after killing Eric. Kouri Richins asked Josh if he had ever killed anybody. Killed was her word. Not have you ever lost a loved one. How do you agree? Not have you ever walked in and found a dead body unexpectedly. Not how do you respond to a tragic and horrible accident. It is how you have you killed. And then she asked how it made him feel. She asked that because she was working through her own feelings on killing and wanted Josh to help her work through those feelings. And never mind that that's a highly selfish question. She's worried about working through her feelings on killing. Never mind Josh Grossman's feelings on having had to have killed in service of his country. It was her feelings that mattered. The walk the dog letter. There's a lot to unpack in this. But right now, let's unpack the fact that Kouri Richins says Eric gets pain pills and fentanyl from Mexico. She goes on to talk and says, Eric finally told me and asked if Carmen could get him some pain pills and fentanyl from Mexico. Some refers back to pain pills in Mexico from fentanyl. Sorry, pain pills and fentanyl from Mexico. Kouri Richins knows 4 months after she's been arrested for Eric Richins' murder, a year and a half after she murdered him, she knows that she bought fentanyl, and she has to explain it. And how does she explain it? A year and a half after murdering Eric Richins, she blames it on Eric. Oh, I bought it for Eric. That's the sum of the evidence. Her self-serving statement asking her brother to testify falsely that she brought it from Eric, for Eric. Year and a half after she murdered him. Kouri Richins did not tell the 911 dispatcher, hey, I just bought some fentanyl for Eric. She didn't tell the paramedics, he might be dying from the fentanyl I just bought for him. He didn't tell the deputies that responded. He didn't tell Detective Woody. He didn't tell Dr. Ulmer. Didn't tell Christensen. Didn't tell her friends. Didn't tell her family. All the off-ramps she had the opportunity to take to say, hey, I bought the fentanyl for Eric. She doesn't, because it did not happen. She did not concoct this story until a year and a half after she killed him. And it is a story. It's a fake story that she wants her brother to testify to. There are, of course, other inaccuracies. Kouri Richins in the Orange Notebook writes, self-servingly, when the EMT walked up to me and said he didn't make it, we did all we could, I lost it, I immediately ran to the bathroom. This is the video of when the EMT walked up to her.
There's two kids that are waiting there in that door. Yeah, she fit to the left. Yeah, I think that's what master bedroom. Or the master bedroom. So basically, she said went to bed at 9:30. She slept with the kids because then she goes to bed. And when she was in bed, around 3 o'clock, moved into her bed.
We'll stop it there. We could play it for several more minutes. She doesn't immediately or otherwise run to the bathroom and throw up. When people make up stories, they are inconsistent in the retelling. Here in the Orange Notebook, Kouri Richins says they make the Moscow Mule and the lemon drop shot in the kitchen, and then they go to bed and brush their teeth. Here, they drink it in the bedroom, not the kitchen. Kouri Richins tells her attorney, it's on the right, she tells her attorney that Eric was on the phone when she went into Ashton's bedroom. But Eric Richins' phone activity tells a different story. Kouri Richins repeatedly said that she went into Ashton's bedroom 9:30, 9:45. Eric was off the phone before 9. In the Orange Notebook, Kouri Richins says that Eric was awake when she went into Ashton's room. In that rambling phone call with Bryce Knutson that Chelsea Barney recorded, she suggests that he was asleep because she says when she returned to the bedroom about 3 a.m., Eric was in the exact same position as he was when he fell asleep. That means she was there when he fell asleep, not in Ashton's room. Her story is inconsistent in the details. That proves that much of it is fake. We've read text messages throughout this presentation. We'll continue to publish some more for you to read. None of those text messages were recovered from Kouri Richins' phone. They were recovered from Eric's phone, Chelsea Barney's phone, Josh Grossman's phone, but not Kouri Richins' phone, because they were deleted. That is part of her cover-up. When comparing the contents of the phone with few to no text messages, with the contents of the call detail records, with thousands of text messages, that's how we know they were deleted. When Detective Woody executed the first of the search warrants on April the 13th, 2022, and she informed Kouri Richins that toxicology showed that Eric died of fentanyl poisoning, Detective Woody seized her phone. On her phone that she got to replace the seized phone, on the phone that Kouri Richins got to replace the seized phone, these are the searches. What was Kouri Richins worried about? She was worried about the police recovering all her deleted text messages. Why? They're inculpatory. They would further prove that Kouri Richins bought drugs from Carmen Lauber to then murder Eric Richins. Her phone searches reveal what she was thinking. Worried about being investigated. She's worried about having to take a lie detector test. She's worried about my office. She's worried about her seized electronics. Prison is on her mind. So is money. She's interested in the life insurance. We don't know precisely when these searches were conducted. It's just not in the digital data. We have the data we have. But we do know that she hasn't been paid out yet on life insurance. And she started getting paid out in June of 2022. And this phone she got in April of 2022. So the inference is that these searches occurred between April and June of 2022. This one's the most insightful. If someone is poisoned, what does it go down on the death certificate as? She didn't search if someone accidentally ODs. She doesn't search if somebody is dead for unknown reasons. She searches if somebody is poisoned, because that is what happened. Now we have to prove that Kouri Richins intended to murder Eric Richins, which means we have to prove that Eric Richins did not commit suicide. Kouri herself says he didn't. No mental health concerns. But the other evidence proves it as well. Eric had every reason to live. The first three of which are Carter, Ashton, and Weston. He was a phenomenal father. He protected his boys. He put his money in trust mostly for the benefit of them, to protect them. He was a protector. He's not leaving his boys. He was also planning for the future. He was a successful business person, and he and Cody had future business plans. He had future plans with his sister. They were planning family vacation to Disneyland. He was planning on buying a cabin in the Uintas with his father for the family. Every shred of evidence in this case proves that Eric did not commit suicide. This wasn't an accidental dose. Eric Richins did not use drugs. He did not use illicit drugs. Set aside THC gummies. Richins said no, never. Deputy Wynn and paramedic Offred. These are people that it would have made sense to tell he used illicit drugs to in the moment as paramedic Offred's trying to save Eric's life. But no, she was honest. Nope, never. Same thing with Dr. Ulmer as they're reviewing the and trying to explain the fentanyl, right? Dr. Ulmer's like, well, there's this fentanyl, really can't explain it. Did he do illicit drugs? No, never. Grossman, she's honest with anybody. She's honest with Grossman. No, Eric did not use drugs. Her best friend, another person she's honest with. Nope. Life insurance company? No. Chief medical examiner? No. And every bit of evidence that came into this case, everyone who testified and knew Eric well, his friends, his family, no, Eric didn't use illicit drugs. Not even prescription drugs. Your Honor, this might be a good place to take a break.
Let's do it. Folks, one moment, just a friendly reminder. Don't talk about the case. Don't allow anybody to talk to you about it. Do not do anything with your devices during this break related to this case at all. We'll return at 10:20. Please rise for the jury. Court's in recess until 10:20. Thank you.
Okay. Is it frozen now? Oh, Lord. Hang on a minute. Okay, sorry, my kids are fighting. Yeah, I'm not going to mess with anything if it does get laggy because it seems like it keeps fixing itself in short order. We're having really bad weather right now, so I was a little bit worried about this. Yes, so it looks like they have about 12 more minutes before break. We were a little bit behind, so I'm going to catch us up with that. The break in the middle of closing arguments is kind of wild to me, but it seems like he is breaking this down by charge, like going through proving each one. So it kind of makes sense that there's a break. And since there's no time limits, he might have been sensing from the jury that they were looking a little antsy, or maybe it was just a good stopping point. I do love that there are not time limits because it's allowing him the time to be really thorough and go through each and every part of the evidence and testimony, especially because like I've been checking my DMs while watching, and a lot of people are like, it would have been nice to have this summed up during testimony, and that's not the part of testimony or evidence. It's to get these facts on the record to sum it all up during closing arguments. So this is the time to go back through all of the evidence that was presented and tie it all up with a nice bow. So that's exactly what he's doing, and not having the time restriction is allowing him to be extremely thorough. So I just think he's not close to being done. Okay.
Okay, eat some.
Okay, so we're caught up to live. Let me double check I didn't pause it like I did last week. No, we're good. Hopefully that where it froze and got a little bit laggy, hopefully that was like during the judge sending the jury out, and it'll have time to work itself out before they come back. But yes, Heather said, might I say he's doing a kick-ass job. He really is. And I love this style of closing argument a lot more than like Alan Jackson's, for example. Alan Jackson reads off of a script. He has his narrative. It sounds like you're listening to a novel. His presentation is good and it's captivating, and he's just a fun attorney to watch. But Bloodworth, the way he's doing, like he's educating them, he's going back to the elements of the charges, weaving it all together with the narrative and the evidence is just so powerful, I think, because obviously he's a prosecutor, Alan Jackson's a defense attorney, so their purpose is different. But Bloodworth, his style is very much like, you should trust what I'm saying because I'm backing it up with receipts and facts that were presented to you. It's not emotional like Nicole just said. Jackson's is more emotional. He's playing on your emotions. He's captivating you. He's telling you what you want to hear. And Bloodworth is going, here's my crimes I charged. Here's the elements of them. Here's the evidence presented, and we're marrying them together. And like Sydney said, all with no notes. Like, credit to Bloodworth. I can only imagine his preparation for this. But it's so on point. Like, it's not giving, this is rehearsed, this is my time to shine. It's giving, I genuinely want justice for Eric, and I'm confident in my case that I brought and tried. And it's just so good. I actually really appreciate his style. And while we are on a little break, I'm going to refresh the stream. And like, how long has he been going? I feel like they started right on time and we're almost 2 hours into it. So he's been going at least an hour and a half. And I have felt hooked the whole time. I haven't felt like it's going too long. I haven't felt bored. I haven't felt any of that. Let me know if you guys have. Also, we are like, let's see. We are about, I want to say like 7 people away from having 500 subscribers. Yes, seven people. So if you're here, I'm sure all of you are already subscribed. But if you haven't, please like the stream and subscribe. And we're almost to 500. Let's see what you guys are saying. Let's go to the chat. I do have court pulled up. I will bring it back up. I just refreshed it. Okay. Sid says, I'm on the edge of my seat. I love a presentation and love that he's referencing all of the exhibits. Yeah, I feel like the use of Kouri feigning ignorance, as he said, with the medical examiner, with her prescription, is just like a prime example of him tying this whole story together. Because that's what we all said, like, girl, how are you going to play dumb when it's your own medication? And him using her words with other facts in the case and how they contradict each other is so good.
Why did you say that word?
I didn't. Aaron says totally it isn't over the top, doesn't look like he's trying too hard. He's just stating the facts and making it make sense. Couldn't agree more. And Sydney said, and nothing was better than Judge M telling Lewis to sit down and be quiet. Yeah. Not really what she actually said, but that word in my house is not allowed. So I interchanged it. Nicole said, let's see, what wasn't the majority of the jury men as well? So the facts and to point. So the facts and to the point is a smart play. So actually the jury is 6 women, 6 men, and the deliberating jury is 4 men, 4 women. So it's exactly even, and the alternates are even as well, which is interesting to me. Ooh, Judge is back 5 minutes early. The use of her own actions proving her guilt is top tier. And the consciousness of guilt, the way he's using that, where a lot of people were like questioning it, he's using the consciousness of guilt and pairing it with evidence to show like she had a reason to be lying and writing this self-serving orange notebook. Like him using self-serving is just giving to me because that's what we've all said. In Utah, juries are 8 unless it's a death penalty case. Then they have 12. Freaky Tiki said, just so curious about this. Did the walk the dog term get explained to the jury? In his closing argument, he referenced the walk the dog letter. And I think he might have had it on his presentation. I can't remember. But I think they understand the walk the dog title because that's what it was wrote. But the argument, like that it meant what to do, has not been explained. I don't know if it will because that was never brought into evidence. Like they never asked anyone, what was your understanding of walk the dog? Or they could have asked O'Driscoll, like, have you ever heard the term walk the dog? Or what do you know that to mean? They never did that. So I don't know if they're going to argue what that means. But I was shocked how many people knew what that meant because I definitely didn't. I just thought it was some dumb code word she had. But in stories or on Instagram, tons of people said that's a very common term in the military and that people knew that. So hopefully somebody on the jury puts 2 and 2 together. At the end of the day, I think the implication is there. She was trying to control the narrative and have them falsely tell her story. And that's all that they really need. Why not ask the detective? I had no idea. I hope the jury knows. Right. Like that could have been so easy for them to ask somebody, like, did you know what this meant? I definitely didn't know. My mind was blown when somebody told me what that meant. I was like, wow, genius. So, yeah. And then what else was there? I mean, there's so much that like I said, I'm going to have to watch this 3 times because every time I think I'm going to pick up on something different. What else was there? His use of like the presentation is on par, and that's exactly what I expected to see with them. And the pictures and the testimony with like other statements, that was so good. What? Okay, wait a minute. Dr. Trey said, what does it mean exactly? Throw it away like you do dog poopy. That's funny because that would. No, so walk the dog means what to do. Like, so the way I look at it now is like walk the dog is a directive, somebody telling you to do something. So the term walk the dog to me, this is how I remember it, is like, I'm telling you to do something, do it. That kind of thing, like make a plan. Here's what you should do. It's like an instruction, basically. Does that make sense? Because that's how I remember it. It's like, if I tell somebody walk the dog, I want you to go walk the dog. So it's her way of saying, this is what I want you to do, and this is what needs done. You need to go tell so-and-so. This is what the story is. And, okay, hold on a minute. And she doesn't help herself when she says, take vague notes so you remember it. Remember it. Right. Like, 1000% her saying. Also, I think part of that is because the walk the dog letter was, they believe that she held it up during a video conference so that it wasn't recorded, like her statements. So I think the take vague notes was like her telling her mom, write this down so you have the gist of the story. And because I can't send this to you, they'll find it. I can't read this to you, they'll hear it. So it's like, I need to convey this to you, take notes, and then carry on with the plan. Did I miss anybody else's chats? Let's see. I see the judge's head just bobbing in the bottom. He's like, I'm going to be on time. Let's get this show on the road. It's also not been addressed because I saw some people asking on Instagram how late they're going to let the jury deliberate. And I cannot remember if this court ends like Massachusetts.
231-500-139. Mr. Bloodworth, are we ready for the jury?
Yes, Your Honor.
Ms. Lewis?
Yes, Your Honor.
Let's do it.
I love how he says, let's do the thing. Like, he's just so cool. And like Cindy said, if that's what truly happened, you wouldn't need to relay it. Everybody would just know. The truth is the truth. Okay, is it laggy? Are we good? How's it look?
Please. Please have a seat. Mr. Bloodworth, you can make sure that mic is on, and please proceed. Very good.
Thank you, Your Honor. We call it the outset of closing when we were looking at the aggravated murder charge. I mentioned the first two elements of murder, and then we get into the two aggravators. So the closing up now has been the murder charge. That is straight murder, but the state of course has charged aggravated murder. So now we'll talk about the two aggravators. The why aggravator, money motive, and the how aggravator.
Okay, that was truly unhinged. I do not know what just happened. I am in a full-blown panic attack because I don't know what happened, but we're back. So we're starting from them coming back from the break. Holy moly. I saw the power line people driving up and down my street, so I don't know if that has something to do with it. Yeah, that's wild. Okay, let's go.
Please have a seat. Mr. Bloodworth, make sure that mic is still on, and please proceed. Very good.
Thank you.
Wash your hands. Oh my gosh. This is wild.
At the outset of closing, I'm looking at the aggravated murder charge. Mentioned the first two elements are murder, and then we get into the two aggravators. So the closing up until now has been the murder charge. That is straight murder. But the state, of course, has charged aggravated murder. So now we'll talk about the two aggravators. The why aggravator, money motive, and the how aggravator, administering any substance in a lethal amount. You'll recall Brooke Carrington's testimony. And when she began her forensic accounting analysis, this drew her attention. The number of overdraft and non-sufficient fund transactions beginning in April. That jumped from 1 in September to 37 in October, beginning in October. That jumped from 1 in October to 77 in December. Brooke says was of the downward financial debt spiral. Then Ms. Carrington analyzed the overall debt, and it showed a growing debt nearing $8 million debt. Kouri Richins closed on the Midway Mansion.
Thanks for watching. Make sure you